Any mention? Supplementary list, item number 1.
May it please, my lords. This is an appeal.
With the final order.
My lords,
If
it's
it is
not,
a direction as part of the final order,
my lords,
then
if it had been in my favor, a status quo in my favor, pursuant to my lords, a certiorari issuing, then there was no difficulty.
not necessarily in your favor. Once a final order is passed,
My lords, then there cannot be any further interim arrangement. There cannot be any further interim
what is, the
arrangement.
language what is the language of the order?
My lords, I'll take your lordships to the findings, my lords. If my lords kindly come to page 236, my lords, paragraph 16. Last paragraph, my lords, at paragraph 16, down below, last 2 lines at 236.
Yes.
Well, as this court has come to a finding that the impugned order is unsustainable in view of the same being visited by arbitrariness and there being a breach of the principles of natural justice, the same is set aside and quashed. So the impugned action is quashed, my lords. However, as no interim orders have been passed and the impugned order having been passed as far back as on 28/4/2025, it is ordered that status quo as of today shall be maintained by the parties till the matter is disposed of, or further orders passed by the respondent number 2 and 3. So, my lords, the interim arrangement, my lords, restores the position prior to the issuance of the certiorari.
What is the matter to be disposed of?
My lords, what had happened is, after the matter had been argued at, my lords, length and the matter was reserved for judgment, the matter came up as to be spoken to. That is when, my lords, the respondent number 4, my lords, agreed to file a additional affidavit. Matter was reheard. That's when, my lords, the primary respondent, that's the Indian Golf Union, then said that we are willing to revisit the decision of, my lords, de-affiliating us. That the learned trial court, my lords, learned single judge permits. And, my lords, he says that your decision is wrong, so I'm setting it aside. Gives them liberty to revisit the decision, my lords. There's no question of revisiting it because it has already been set aside. It can be either, my lords may exercise a power or say that, okay, very well, we are not exercising it. You go and do the needful and come back to this court. That was one option. That was never done. The learned single judge goes on to, my lords, declare it as illegal and sets it aside. Then says, till you take a fresh decision, let the status quo be maintained. Meaning thereby, my lords, that the respondent number 4, who's the other body, who's the other respondent in the matter, my lords, he continues in the internet.
In other words, it has allowed the
impugned action to continue.
Not the impugned action to continue,
my lords.
But as far as the impugned action per se is concerned, that has been set aside.
My lords.
It has allowed the authority concerned to revisit its
to that extent is okay, my lords. To that extent also, my lords, if I may say, it is okay. The difficulty is, my lords, then you cannot have an interim arrangement where a third party, my lords, who was a beneficiary of an illegal order to continue.
No, that of course.
That is the effect of this order, my lords.
Okay.
That is the effect of this order. If my lords are issuing a certiorari saying that a certain action is bad, So any beneficiary of that bad action cannot be the beneficiary of the orders passed by this honorable court by way of an interim order. That's one part of it. The second part which we are aggrieved by is the learned single judge also finds in this judgment, and I'll just point out, the finding at page number 13, of the impugned judgment at page 231, if my lords kindly have a look.
Page number?
13, page 231, paragraph 13.
Para 13, yes. Yes, what does this say?
A plain, because what had happened is there was also an arbitration clause. Now, the learned single judge says, that even though I am de-affiliated, the arbitration clause will still continue to be. So, I am aggrieved by that. Now, at this stage, what I am praying before your lords, I would humbly submit that this would require some hearing. I would only pray, let the appeal be formally admitted. And, a date be fixed for final hearing of the matter. And till then, there is a prayer for interim stay. I am not even pressing it at this stage, because some time has gone. What I am only saying, may direct a date, an early listing of this matter where the entire matter can be heard and disposed of.
Notice issue?
We've served copies on all the respondents.
My humble prayer, my lord, the writ appellant has a grievance. Judgment has been delivered by learned single bench. It contains two directions. One is allow me to revisit by giving opportunity to all the parties. Second one is, in the meantime...
You are IGU?
Yeah, IGU. In the meantime, the status quo need to be maintained. What my friend has a grievance is the second part, and the reconciliation forum. With regard to the first direction, setting aside the impugned notice, the affiliation, he is not aggrieved with. He is not aggrieved with the opportunity to be given to him. That was his prayer only. I have taken a decision without giving opportunity. So IGU action is wrong. So set aside and give me opportunity. So single bench has granted that one. In pursuance to this, we have issued show cause notice to him. Now, learned single bench directed us to take a decision within 2 weeks. Now, what we have the situation here is, after issuing a notice, writ appellant is taking the plea that I have filed an appeal. So don't take any decision until the division bench take a decision. So my humble prayer today is that with other issues, Lordship may fix the date for final hearing. But with regard to the issuance of show cause notice and taking final decisions, my Lord, Lordship make it very clear that it may not be impeded.
It cannot be, it cannot be.
Okay.
Yes, only that part. Other issues, Lordship may fix the date.
If your issuance of the show cause
yes.
would affect the merits of the appeal, then...
it's because as I submitted, either your lordships exercise a power of certiorari, set it aside. Or your lordships say that we are not exercising the power, we are allowing the respondent who is responsible for issuing the order, you take corrective measures. It cannot be both. Both cannot coexist.
Lordship, can you see the operate portion of the very judgment? Page number 263. Two paragraphs. 236. Para 15 may I read, my lord. It may also be recorded herein that in the early arguments of the respondent number 2 and 3, that is me, the submission made by such no learned counsel for the respondent number 4, and submissions made by the learned senior counsel on behalf of the petitioner society, considering the nature of the case and its implication, such learned senior counsel has submitted that the respondents number 2 and 3, on submission of this appellation, are prepared to examine the matter afresh by giving the petitioner society adequate opportunity to present its case. The submissions are duly noted, and as such, in view of this development, this court accepts the concession made by the respondent number 2 and 3. It is accordingly directed that the said respondents shall examine the matter afresh by giving the parties in contention adequate opportunity to represent their respective cases. As this has come to the finding that the impugned order is unsustainable, in view of the same being visited by the arbitrariness and there being a breach of principle of natural justice, the same is set aside in quash. However, as no interim order has been passed, and the impugned order has been passed as far back as on such and such, it is ordered that status quo as on today shall be maintained by the parties till the matter is disposed of, or further order is passed by the such and such. No, my learned friend is aggrieved with this second portion.
I am aggrieved by both. My friend will not put words into my mouth.
Can you see his prayer in the writ appeal? The prayer made in the writ appeal. That is page number 39.
Prayer in the appeal.
No, but Mr.
Page 20.
Page,
Mr. Sankesu, see, at this point of time, what Mr. Paul has submitted is this: appeal will be admitted, parties will be heard. As far as interim prayer is concerned, he is not pressing for that. So finally, the appeal can be heard.
I have no objection.
My lords may fix a short date.
Filing of the hearing of the appeal on merits. But with regard to my lordship, his prayer, page number 20, 21 of the writ appeal.
When the merits is looked into.
Therefore, I am trying to make a distinction. The grievance that protested by learned friend here, page 20 and 21. The prayer in the writ appeal. He is not challenging the entire.
No, it is. I don't know what my learned friend is reading.
See.
Prayer 1, my lords may kindly read. Quash and set aside the judgment on order dated 5/8/2025 passed by the learned single judge.
To the extent it is challenged. Well, to the extent it is challenged. No, he is not challenging about even giving show cause notice to him.
That will be looked into.
At the stage of final hearing, my lords will decide.
All the respondents are present.
Everybody is served.
Heard Mr. Paul and the senior counsel. Along with Miss. Being aggrieved, the appellant being aggrieved and dissatisfied with the order, with the judgment and order dated
5/8/25, my lords.
5/8/2025 passed in WPC 154 of 2025. This appeal was accordingly preferred with the prayer made therein. However, before launching into the merits of the matter, the learned senior counsel has submitted that all the respondents having been earlier put to notice, and on acknowledgement of such notice has appeared today in court. Therefore, this appeal may be admitted and the matter be fixed for hearing of the same. Indeed, all the respondents have put in their attendance before the court today. As such, no formal notice is required to be issued upon such respondents. In view of the submission made by the learned senior counsel for the appellant, this court is, and on perusal of the appeal judgment and order, this court is convinced that the appeal be admitted. The same is done so herein. As prayed for. Do we fix a date or what do we?
My lords may fix a date.
No, we cannot fix a date because we don't know when this bench will sit. 1 week.
At the earliest, my lord.
At the earliest.
At the first available bench, my lord. The first available bench.
Accordingly, list this matter for hearing up to 1 week.
Yes. I'll be obliged.
Okay.
Then daily list item number 1.
Please, Lordship. Lordship, I'd like to mention item number 4, my lord. I'm praying for some accommodation, my lord, on this matter.
No objection.
Lordship, matter would come over after a week's time, my lord.
2 weeks.
2 weeks.
On pre-made by appellate. This is matter of 2 weeks.
All right, Lordship. All right.
May I please, Your Lordship? Your Lordship, first of all, I would like to tender my apology, Your Lordship. Item number 2 from the supplementary cost list, Your Lordship. Yesterday, I had prayed for time that this matter may be listed today. But today, Your Lordship, the conducting counsel, Mr. SN, is having some medical emergency, Your Lordship.
No objection, Lord. In fact, his junior, my Lord, Mr.
suffered
Adaya,
a
our singer, he suffered a stroke
stroke.
yesterday, my Lord.
Oh,
So he's undergoing treatment. He's, I think, paralyzed on the left side.
really?
Young boy, my Lord. So very unfortunate,
Very, very unfortunate.
my Lord. So, my Lord, may I kindly have it next week or the week after that?
On prayer made by Ms. Banerjee, seeking accommodation. Matter not received, not be objected to by Mr. Philip Nobri, counsel with petitioner. That is adjourned. This the same after 1 week.
Deeply.
Much obliged, Lordship. On supplementary list, item number 1.
May I please, Your Lordship? Your Lordship, in this appeal, appellant is the original claimant also, Your Lordship. He is the father of the deceased. And this appeal has been arose out of the judgment passed by the learned tribunal dated 25/4/2025, Your Lordship. Passed in MSC case number 8 of 2013, Your Lordship. So in this case, Your Lordship, the original case has been, claim petition has been filed. It is in the year 2013. And this case has been registered at MSC 8 of 2013. So it is an accident which happened at Barniat, Your Lordship. And the deceased was death by the vehicle, one track, number S01BC9073. So after filing this claim petition, original claim petition, Your Lordship, the learned tribunal has framed 5 issues, Your Lordship. So all these issues has been decided in favor of the appellant claimant, Your Lordship. But only contention, our contention is that we agreed for the competition of
Quantum.
Yes, quantum of enhancement of this quantum, Your Lordship.
Heard Mr. and I Chaudhary, learned counsel for the appellant, was submitted that the appellant being aggrieved and dissatisfied with the judgment, order dated 25/4/2025, passed in MAC, passed by the learned member MACT, East Khasi District Shillong in MAC number 8 of 2013, has approached this court with this appeal. On consideration or on perusal of the memo of appeal and the impugned judgment, this appeal is accordingly admitted. Appellant to take steps for issuance of notice upon the respondents. The notice returnable within 2 weeks. This is the matter thereafter.
High Lord.
From the list, item number 1.
Your Lordship, in this matters, Your Lordship, when last question we were hearing, and then we came to this whether I need some instruction regarding matters, do we don't file a press or amend the this prayer of this petition, Your Lordship. So what's happened, Your Lordship, in between this Mr. Khan was the main lawyer in this case, Your Lordship. So he was sick, and then I was not in a position to thoroughly discuss with him, and I need some other documents for this particular purpose. And whatsoever I gone through, Your Lordship, this matters, thoroughly I have to examine these matters, what type of petition to be, if you would also go to be defined, and then discussion record with the parties, and party was not available. So I need some accommodation, Your Lordship, in this matter, Your Lordship.
In this case,
If I go for even with
you're the
also
lawyer
party,
here.
or if I make the pair amended also, Your Lordship, then petition will be required, Your Lordship.
Lordship, I have a strong objection in this point. Last 7 days, 7 times I have visited. He never informed me anything. Last occasion also, this honorable court heard the matter on length, and he wanted some time for instruction. And prior to that also, he prayed before this honorable for providing some time due to his illness. But he was standing in the lower court. I went there and I
Your
have seen.
Lordship.
It is my, yes.
Your Lordship, may I clarify, Your Lordship?
Let me.
Just a moment.
Let me. Previous date, he told me that some person died in his family. That is, I also never made any objection. Today, I have objection whether he will go to the case, because it is an offsuit. The IA petition, which was filed by the petitioner side, is an offsuit of the main revision petition. And in this revision petition, Lordship, they have challenged 2 orders. One for substitution in the year passed in 12/7/2019, and subsequent order of the dismissal of that review petition, which was filed without any condonation petition. It is totally barred by limitation. That point also we argued last occasion, Lordship. It cannot, if we will proceed with the case, what the result will be come out from this case? And he is always taking time in the name of some Mr. Advocate Kind. I have never seen him in lower court also, before this honorable court also. In the 3-4 years, I have heard his name.
Your Lordship, in the order, this earlier court order, his name is there, Your Lordship.
Forget about it.
And Your Lordship, just I will clarify in this matter, Your Lordship. On the last occasion, when I have taken, Your Lordship, I was sick and I was having lots of pressure and I was having pain in pain. Then what's happened, Your Lordship? In respect of this matter in the district court, opposite party to examine the witness. So that's why court says just my presence is required. And then I went, and after this is okay, you go. And in presence of the council. And after this I came out. So Your Lordship, when the court is asking to my presence only just to my face, can I deny, Your Lordship, that I am taking the matters in the High Court adjourned? Can I ignore this court?
Adjournment may be taken
So,
by
Your
the
Lordship,
junior also.
when I've taken,
If he is not well.
I am not so sick that I'll be bedridden, Your Lordship.
We'll not go. We'll not.
I
go,
am also not good.
We'll not go into personal matters here.
So Your Lordship,
Yes, Lordship, I don't want to.
Your Lordship,
See,
this matters
what-
one is saying this.
As of the present, now this matter has been going on for quite some time. You have been given, enough time to, to get your instructions and make necessary, correction or modification or steps to be taken. You have not done. Now we are saying you need, somebody.
Little bit
to,
accommodation.
you cannot just go on like this.
Some etiquette must be there to inform me.
Yes, in fact, you should have informed,
Yes, Lordship.
her that you intend to seek for time.
I beg apology.
That is basic courtesy. We used to say,
This is
even
my
in court.
mistake, Your Lordship. I apologize, Your Lordship. I apologize on this. It was my mistake, Your Lordship.
If you're not prepared to be heard on the matter, see, the court can understand. If you're not prepared, the court can understand. We will accommodate you, but you don't come with those kind of excuse.
Today is only fixed for instruction of the client. Last occasion, Lordship,
Okay,
the matter.
fine. We'll do one thing, Mr. I'll give you time. You get your instruction. and you take steps. If you are instructed to withdraw or do whatever you like, file an application or what, do it, but no more accommodation will be given. On the next date, there will be, this matter was heard on merits.
No, Lordship, because condonation petition itself is
No,
not.
only on first, I'm not talking about the
Yes, Lordship.
only merits of the
I can argue in any point because there is no merit. After 6 years of filing of that substitution.
When do you want it?
Lordship.
You fix a date.
Yes, Lordship.
You suggest a date when?
Next week, Lordship.
Next week when? Yes.
Today 9.
Should we do it on 17?
Yes, Lordship.
Mr. 17? No more adjournment. Mr. R. Debnath, Learned Counsel for the petitioner, has once again sought for accommodation on the ground that the necessary instructions have not yet been received by him from his client, for which he is unable to proceed with this matter today. Ms. M. Deb, Learned Counsel for the respondent number, your phone number?
Respondent number 2.
Respondent number 2 has strongly objected to the prayer made on the ground that the petitioner has sought for adjournment on for several dates. As such, it would as such no further adjournment may be allowed. Mr. H. Karolang, Learned Additional Senior GA, appears for the respondent number 1. This court has considered the submission made, and although the fact that the matter has been lingering for quite some time, the fact remains that the merits has to be looked into by this court, for which parties has to be given ample opportunity to present their side of their case, to present their arguments. Accordingly, the prayer made is allowed. It is made clear that the petitioner is to take necessary steps if so desired within the next date fix, for which no further adjournment will be allowed, as prayed for, as agreed to by the parties. This is matter for hearing on 17.
Obliged.
Item number 2.
Service is complete, no?
May I please, Your Lordship?
Yes.
Our Lordship recently received the communication from the IO with regards to status of the notice, Lordship. Notice has been effected, Lordship. But then
What is the observation?
Observation.
What is the observation? Whether the complainant would like to
Lordship, I have not received any instructions with regard to whether she'll be appearing or not.
No, but that is exactly the purpose of the notice to IO,
Lordship. But then I've
that he has to confirm. See, time and again we have said this. Firstly, he has to ensure notice is, is received by complainant. Number 2, whether he or she would like to contest the case. Number 3, whether he or she will engage a private counsel or seek legal aid. That's all.
Lordship.
That has to be there.
Lordship. Lordship, pray for weeks time and I'll file a compliance affidavit, Lordship, or report.
POCSO matter.
Also, this is the second round of, this is the second bail application.
What is the stage of the case?
Stage, my lord, is, my lord,
Evidence.
evidence, but however, my lord, from the date of charge sheet is already 11 months and only the survivor has been. On the last occasion, my lord, the only strong objection from the claimant, the survivor side was that, my lord, since the accused as well as the survivor is from the same locality, if he is released on bail, my lord, they might, my lord, come in contact. So now in my second bail application, my lord, the brother-in-law of the accused from Shillong has filed a, my lord, declaration saying that as and when he is released, then he will be shifted permanently to Shillong, my lord. That is the second ground. So lord, we'll wait for a week, my lord.
Mr. AHR, Leonard additional PP has submitted that
Lordship.
the IO has filed the compliance report as far as service upon the respondent number 3 is concerned. However, apart from the fact that the IO has confirmed the issuance of the said notice, no observation has been made as regard the decision of the complainant whether to firstly whether to contest this case or not, secondly whether she would engage a private counsel or seek for legal aid. Under such circumstances, the learned additional PP has submitted that some more time may be allowed to get a clarification on this aspect of the matter. Accordingly, the IO is directed to file a comprehensive status report, compliance report on the next date fix. This is matter after 1 week.
My lord, if this matter can come up on 19th, my lord, I'll be out of station, my lord.
This is matter on 19.
Item number 3.
This is the CMJ matter, my lord. We have to, I with Mr. Nongwe have instructed to appear in this matter, my lord. We are appearing today. My lord, by last order, they are supposed to file authorization because there are many petitioners in the petition, my lord.
Yes, yes.
Yes, Lordship, but however, Lordship, some of the authorization letter is yet to received. So therefore, Lordship, I'm praying for another 3 weeks' time, Lordship. I'll furnish on the next date, Lordship. In the meantime, Lordship, I humbly pray that some portion in the prayer of the petition, Lordship, needs to be amended. So, Lordship, if Lordship may kindly allow...
You file a petition.
Lordship.
You seek for amendment and file petition.
Not only prayer, my lord. They have to plead, they have to establish. If Lordship kindly sees, my lord, they are saying that they are a student of CMJ University. Now, nowhere they have annexed certificate, which year, what subject, when they passed from CMJ University, and not a single document, my lord. Not even pleaded a case, and simply challenging an order issued by CMJ University, my lord. So without even indicating the basic facts, my lord, whether they have a locus to file this case.
No, whether they have annexed copies of their
nothing, my lord. Kindly see, my lord.
Lordship, may kindly allow us to amend the petition,
withdraw
Lordship.
and file a fresh petition.
Then, Lordship, it will have to get instruction, Lordship, because...
see, if you withdraw this petition, you file a fresh petition.
Lordship.
One thing, you will cover the issue of authorization. Next, you will cover all those lacuna as has been pointed out by the learned DSGI, and your petition will be complete. Otherwise, you come again and then something or the other comes up, you'll have to.
It's a fresh petition. They can easily withdraw
But
it.
Lordship, this matter is from Guwahati, Lordship, so I'll have to seek instruction first from them, Lordship.
Okay, we'll list this matter tomorrow.
Lordship,
You get your instruction whether to withdraw it or otherwise.
Lordship.
On prayer made by Mr. and Counsel of the Petitioner, list this matter tomorrow.
Highly obliged, Lordship.
But my appearance.
Dr. N. Musika, learned DSGI.
No, it's a senior counsel, special counsel.
Special counsel. Oh, you are for the administrator.
For the state, all the
For the
response.
state. And along with Mr. Human Nongri, appeared for all the respondents.
Yes,
For the
for
respondents.
response.
Highly obliged, Lordship.
Item number 5. Please, Your Lordship. Lordship, I'm here representing respondent number 3, Lordship. Lordship, in the last occasion, I've mentioned that we tried contacting the complainant, Your Lordship, but then we could not get through. So, Lordship, what I did was I tried contacting the IO of that particular place, Your Lordship. So I got to speak to the IO, Your Lordship, but then she said that the complainant's phone is broken. So she tried to call the headman of her locality to get to contact her. But to date, even recently, just now, Your Lordship, I was trying to call her, but she said that no contact has been through, Your Lordship, to get to contact the complainant till date. So, Lordship, if the court permits, Your Lordship, if the matter can come out tomorrow, just give us few more hours, Your Lordship, to be able.
Yes, what happened is you have been engaged as legal aid counsel.
Yes, Your Lordship.
Last time around, because you don't have a copy of the
Yes, Your
petition,
Lordship.
so well,
Yes,
the court
Your
has agreed that you should be given
Yes, Your
sufficient time to go through. But once you have taken the brief,
Yes, Your Lordship.
it is incumbent upon you to go through the brief
Yes, Your Lordship.
and advise your client accordingly.
Yes, Your Lordship.
So it is not, and this matter is not a issue that certain specific instructions is required.
Yes.
Yes, Your Lordship.
So you have gone through the brief.
Yes, Your Lordship.
You argue on the basis of the petition, and that's all.
Right, Lordship.
Make your stand, and we'll see.
Matter has been already been almost over. It will be over, my lord, by 1 month or 2 months, my lord. Out of 7 witnesses, 4 has been examined, my lord.
Four. Only
4
three
has been examined. Next date is 16/9, my lord.
Okay.
Who knows, my lord, on that day, my lord, 2 more witnesses, my lord, examined, my lord, matter ends there, my lord.
Could be. So we'll hear the matter.
Your Lordship, if the
Kindly hear the matter, my lord, pass order accordingly.
The public prosecutor is on leave as she's some personal difficulties. If it may come up tomorrow, Your Lordship.
Yes, you have to consider. Mr. Sakia is not from here.
Yes, Your
He has come all the way from
Guwahati.
outstation. Can I just see if so? The earlier case I had said the same thing. If there are some inconvenience on the part of the counsel, and you are intending to seek for adjournment, at least have the courtesy to inform the other side. And look here, because of personal difficulty, I'll not be able to come. Maybe the case may not be able to be taken up. And inform him accordingly, or inform her, whatever the case may be. He has come all the way now. You see, so
Yes, Your Lordship.
it's not fair. We understand, problems. We understand personal difficulties. Court will, agree to, but courtesy has to be there.
Yes, Your Lordship.
You cannot just come all of a sudden and say matter not taken up.
My apologies, Your Lordship.
My lord, kindly post it on 12, my lord, Friday, my lord.
Or should we wait for after the 16?
No, my lord, before, my lord, on Friday, my lord, kindly fix
If
it.
16 is finished, then no need to come.
My lord. No, my lord, it will not be over, my lord, by that time, my lord. Fix it on 12, my lord. Pass accordingly order by without any, my lord, adjournment from either side, my lord.
Friday?
Yes, Your Lordship. It will be ready, Lordship.
No more adjournment, my lord, on that day, my lord.
Yeah.
That may be observed.
If any counsel is not prepared, then alternative arrangement has to be made.
On the basis of the materials on the bail petition,
Yes,
my
Your
lord.
Lordship.
Bail applications are usually not to be kept pending for so long.
Yes, my lord.
Mr. P.J. Sakia, counsel, for the petitioner is present. Ms. Sino Clown, Legal Aid Counsel, appearing for the respondent number
Number
3.
3, Lordship.
Complainant has submitted that specific instructions have not yet been received from the said respondent and has sought for time to allow such instructions to be forthcoming. Miss, you are GA? Miss Leonard GA has also sought for completion as far as the respondents 1 and 2 state is concerned, on the ground that the Leonard Senior GA who is conducting the matter is inconvenience on ground of personal difficulties. The preamate has not been objected to by the Leonard counsel for the petitioner, who has, however, impressed upon this court that the matter may definitely be heard on the next date fix. Accordingly, on prayer so made, the same is allowed. As agreed to by the parties, place this matter for hearing on 12.
12. Deeply obliged.
Obliged, Lordship. Item number 6.
My lord, this matter was heard, my lord. At length, my lord had instructed the government side, my lord, to obtain the duplicate copy of the charge sheet to peruse the 161 statement. My lord, with profound, my lord, apology, my lord, I beg to submit, my lord. In this case, my lord, there are 3 accused, my lord. So, my lord, on the about 2 months back, my lord, bail application was moved on behalf of one of the accused. Subsequently, another, Kami, Ronald, and now this is the 3rd one, my lord. So, my lord, I had accordingly sent a WT message to the concerned police station, my lord. Surprisingly, my lord, I received a reply saying that the charge sheet was handed over to me on the last occasion, my lord. So, my lord, I took the, my lord, I went down to my office, checked all the communications and also all the orders passed in the previous petition. Nowhere I could see the charge sheet was ever handed over to me, my lord. So, my lord, with utmost apology, my lord, I may be given a couple of days, my lord, to, my lord, clarify with the IO and get a copy. This has happened for the first time of my practice, my lord. So, my lord, my apology for the time wasted, my lord, also to my friend here.
What can be done?
So we'll take it up on Friday?
My lord, on Friday I am leaving, my lord, the station for a week, my lord, due to personal difficulty. So if my friend can, on 19th.
Month 5, 19th will be a little too long, like Thursdays, if you can accommodate. Thursday is a holiday? Oh, we on 18th. Okay, sorry.
Let's say we have on 19th because I'll be back.
No, we are on, today is the 9th of September.
Yes.
So if we can have it on Thursday or Friday, sir.
I'm leaving on 12th.
So, no, 11th if it's okay.
We make an attempt, my lord, but I don't think, my lord, but
in any case we can, because CD is here.
This is a different district, my lord. It will go through proper procedure, that is WT message. So we can make an attempt, or if I.
Today is Tuesday, 9th.
9th.
Let's fix it on Thursday. Try to.
Well, I'll do my best, my lord.
If not, then we'll have to.
My lord, I'll do my best, my lord.
On Mr. Mr. R. Gurung Lanaji seeking accommodation on grounds of personal difficulty. The same not be objected to by Mr. S.S. Sedap and counsel of the petitioner. Matters adjourned. As agreed to by the parties, this matter for the hearing on 11.
Lordship,
I'm grateful, my lord.
there's a small mention about something else, of course. It's pertaining to yesterday, Your Lordship. Lordship had passed a common order in 3 bail applications yesterday. So while I was perusing the order, Lordship, in the evening when it was uploaded, it seems inadvertently the wrong police station case number has been mentioned in the last paragraph. That just the police station case number, Lordship, that has to be corrected. Instead of Nompo PS case 25 being typed, Sadar 80 has been typed inadvertently, of course, because it was picked up from the FIR, I think. Typographical error. So if that can be corrected.
No, you see, once the order has been passed,
Yes, Lordship.
see, this is not a like in an office or school where you come, you cross, and you
True.
procedures to be followed.
Understood.
Section of 362 is there. Of course, it can be corrected, but you have to file an application for that.
My lord, in the present matter, my lord, if my friend also can make an endeavor, the 161 statements are missing.
I have 161 statement.
Then in that case, my lord, we can have it.
We'll see it day after tomorrow.
Then I can file it.
Okay. Yes,
I can
What this court is requires is only to see if there are any, let's put it this way,
exactly.
prima facie evidence against the petitioner.
Exactly. Yes.
To that extent, of course, in course of hearing, other consideration will come, but that's a different thing.
161 I can provide on Thursday.
So you file a petition, Mr.
For the other, yes. Lordship, if you can allow me to file a common application for these 3.
Yes, you can do that. You refer to the order. It's a common order.
Common order.
Refer to the order.
Good day, Lordship.